Good afternoon, everybody, and welcome to the Spooky Depth of Employment Litigation, Busting Preconceptions and Myths webinar. If you are seeking CLE or CE for today's webinar, please make note of the 3 codes that I will put into the chat box throughout this 90-minute presentation. Once the presentation is done this afternoon, I will send you the materials from today's presentation, as well as a link where you can go and apply for your CL or CE credits, which we ask you to do by Monday. If you have questions for the panelists today, please put them into the Q&A box at the bottom of your screen, and the panelists will answer those questions at the end of the presentation as time permits. I'm now going to send over the presentation to Sean Pierce, who will get us started. Sean?
Thank you, Amy. And good morning, everybody on the West Coast, and good afternoon to everybody else. My name is Sean Pierce, and you are joining us for the Management and Professional Liability Alliance's 2nd webinar in partnership with Perrin Conferences. I want to thank Lindsay Perrin and Amy Williams, who have facilitated what was a really good program last time and what will hopefully be a good program this time. Obviously, with Halloween on the horizon, we wanted to come up with an appropriate name. Hopefully, nothing you will hear today will scare you too much, but will instead put you at ease and help you through any employment issues you may have coming up. We have a great roster of speakers today. I want to go through their highlights pretty quickly, but if you want to read more about them, there are links to do so both on the Perrin website and on their respective firms' websites. Storrs Downey is a named partner with Downey and Lenkov in Chicago. Storrs has been practicing for over 35 years representing management in labor and employment issues. He is a good friend and an excellent speaker, and you will enjoy hearing from him today. Bob Sallander has been practicing for over 40 years in the San Francisco Bay Area. From his firm, Greenan, Peffer, Sallander, and Lally. Bob is going to be speaking to us today about attorneys' fees and combating them, and I know you'll look forward to hearing from him as well. And then we are thrilled to have a new speaker with us this time, Tina Maiolo from Carr Maloney. Tina practices with the firm in the Washington, D.C. area. She is also an experienced litigator and has a lot of experience in the employment arena that you're going to hear a lot about today. I want to briefly tell you about the Management and Professional Liability Alliance. We are a loose affiliation of law firms from East to West Coast, in Chicago, in DC, in the Rocky Mountains, and in Alabama, where I am based here in Birmingham, Alabama, with the firm of Wallace Jordan. We are firms that specialize not exclusively, but extensively in labor and employment, management, and healthcare. You can read more about our firms and our alliance at the website mplalliance.org. We hope you'll check it out. As Amy told you, if you would, not in the chat box, because I always mess this up, but in the Q&A box, please ask any questions you may have. Certainly, if you have any verbal questions that just do not communicate well in writing, we'll be happy to take those at the end. We've allocated time after the hour and a half of dedicated speaking today to answer those questions. We'll be happy to do so. But keep in mind, although we are all lawyers here, we are not your lawyers. Nothing today will be legal advice, but we certainly hope if you have legal needs and if you have any follow-up questions after today's seminar and presentation, you will follow up with the firm or firms that can be of most help to you. Thank you again for attending, and we're going to start out with Storrs Downey talking about the Bermuda Triangle of ADA, FMLA, and workers' compensation.
Thank you, Sean, and a good afternoon to everyone. Thank you for joining us today. We've got 3, as Sean said, 3, we think, really interesting topics. A lot of developments going on with them. My topic is going to be what we also would describe as the Bermuda Triangle, the overlapping nature of ADA, FMLA, and workers' comp. Next slide, please. So I come from the perspective of an attorney who, for the first several years of my career, was defending employers on workers' comp cases in Illinois and Indiana. And about, well, many years back in my career, all of a sudden this new concept, this new legislation came around, the ADA. I said, that sounds interesting. At that point in my career, I moved a little bit away from workers' comp defense and into beginning to represent employers on all facets of employment law, starting with the ADA, and then of course over time the FMLA and a lot of other rules and regulations that go with it. The challenges that I've seen over the years between ADA, FMLA, and comp in part come down to the lack of communication between the different players involved, all on the defense side. You might have a labor employment attorney assisting you as an employer. You might have an EPL carrier. You might have a work comp carrier. You have the employer itself, and you might have the work comp attorney. What I've noticed over the years is that all of those different principals don't get together and share and exchange and coordinate different procedures, recommended programs and actions. It can lead to a big mess. So really the coordination between all the parties is significant. If you want to reduce the types of exposures you'll see with lost wages, back pay, front pay, retro benefits, job reinstatements, damages, punitive damages, attorney's fees, and you'll hear from Bob Sallander later on the whole topic of attorney's fees that we need to combat. Next slide, please. I want to briefly go through a fact pattern that I might come back to, and some of the other speakers during the roundtable might also bring up. So put yourself in the position as a risk manager, as an EPL representative, as a defense attorney. You get a call from an employer. Hey, we've got this employee, Joe, or actually now he's a former employee. We're a warehouse company. We have about 50 employees. Joe's a warehouse laborer. He's worked for us for about a year, a little over a year. At his job, he has to lift over 50 pounds, a lot of standing, bending, lifting. Over the last several months, we noticed that Joe's job performance was on the decline. He wasn't showing up on time, seemed to be goofing off, wasn't as productive. So his supervisor would talk to him and sometimes chastise him. No, we didn't write him up, but we did verbally discipline him. Early January of this year, January 4th to be specific, Joe claims that he was lifting a heavy box and injured his back. Well, no one directly eyewitnessed the accident, but there was a co-employee who heard Joe shout out. And by the way, this was at the beginning of the shift. Co-worker runs over, what happened, Joe? Oh, I was lifting and hurt my back. The co-worker runs off, talks to the supervisor. Joe hurt his back. The supervisor says, I tell you, Joe's been nothing but a problem. The last thing we need is an accident. I'm sure it's Joe's fault. In fact, I bet he didn't even hurt himself. And, you know, this is going to increase our premiums. This is just a big conundrum. Joe manages to get off the floor, walks to the safety department, reports the accident to the safety department. Joe's sent over to the emergency room right after that. Joe eventually files a comp claim. The employer denies the claim. Joe starts treating with an orthopedic doctor. The doctor takes him off work for a period of weeks and ultimately says, Joe, you're going to need surgery and you're going to be off work probably for up to 4 months. The employer issues FMLA paperwork. And the next thing we know, Joe is exhausted his PTO leave, which is runs concurrent with the FMLA period. At the expiration of those 12 weeks of FMLA PTO, the employer tells us we terminated him. He's exhausted his leave, his PTO and his FMLA leave. And you know what? He was a bad performer along the way. So we've washed our hands of him. You as the defense attorney, you as the EPL carrier, throw up your hands. Okay, we've got some issues to deal with here. First, we've got ADA concerns. Did we properly accommodate him? Did we go through the interactive process that we need to here? Could we have kept his job for another month or so? FMLA issues. Are we out of the woods with regards to FMLA concerns, or is there going to be an issue there? And then under the workers' comp procedures. Okay, well, certainly getting rid of him might impact our work comp exposure, but we also need to be concerned about a possible retaliation claim. So how is a court, how is a jury going to address this termination? Are they going to feel that this was a legitimate termination, or was it because of this work comp injury? So that is in play all of the time in the types of cases we and many employment defense counsel, their employers confront, and we're going to talk about that. Next slide, please. So I'm not going to spend a lot of time going through the basics. I'll hit on them fairly quickly here, as we have two other excellent topics from other presenters today. But again, as a brief review of the different laws. So under the ADA, think of it as federal disability discrimination protection. There were state laws already in place before the ADA came about. The ADA has now provided the federal protection against disability discrimination. The FMLA came afterwards and provided for unpaid leave for employees for their own or families' illnesses, health conditions. Of course, then we've got workers' comp, which, with the exception of FELA and Longshoremen's Act, is all state controlled for injured workers. So you have to look at the specific state's law. Similarly, under state laws, we look at retaliatory discharge arising out of work comp injuries and prohibitions against terminating employees because of a work injury. Next slide, please. Which employers are covered? Pretty simple rules. ADA, 15 or more employees. You've got less than 15 employees, you can take the ADA off your concern checklist. You still may have state action in play there, however. FMLA, 50 or more employees. Work comp, you can be a sole proprietor. You can have 1 million employees, doesn't matter on the size. So they're going to be different competing and different concerns. You might have a comp issue, but you might not have an FMLA, or you might not have an ADA. Something that's really become a hotter topic as a result of COVID are the long COVID exposures we're starting to see. Again, we could spend an entire presentation just on the challenges that we're faced with long COVIDs. Our firm has been handling quite a number of comp longer COVID, not just short term, but the long COVID exposures, particularly over the last several months. And we're seeing a growing number of Title VII long COVID exposures, where it's brain fatigue, it's memory loss, and other symptoms. And how are those protected or covered potentially by ADA, by FMLA, by work comp? Those are still developing issues that we're going to have to keep a close eye on. Next slide, please. Briefly on medical certifications and inquiries. As an employer, you're entitled to get from a physician, without violating privacy and HIPAA laws, you're entitled to request and secure from a treating physician any job restrictions, any job limitations for a either an injured employee, and again, we're primarily talking about injured employees because of the interplay with work comp, but someone who's off work with some type of health or medical condition. Similarly, with the FMLA, you're entitled to have the necessary FMLA paperwork completed by the physician outlining the extent of a leave, how long the leave will be. And under workers' comp, again, there are restrictions, but in that regard, you are entitled to get information on the nature of the injury, the length of the disability, how long the person might be off work or restricted. Next slide. The area of leaves of absence, absences, leaves of absence, accommodations probably creates as much litigation as any area, particularly with ADA. Similarly with FMLA, where it's less than 12 weeks in play, and also with workers' comp. Under the ADA, the requirement is that an employer has to accommodate restricted status of an employee, the restrictions, the physical, medical restrictions they're under, if it does not cause an undue hardship. That's where the interactive process is so key, where the employer, the employee work together to determine is it economically feasible and reasonable to be able to place the employee in a lighter duty position, whether it be shorter or longer term. FMLA, we're not necessarily talking about restricted status. We're talking about the person is off work intermittently for periods of time. Well, the FMLA provides that if it's a serious enough health condition, yes, you're going to have to accommodate their different swaths of time off work, even if it's not consecutive. Workers' comp, a whole different animal. You might have to accommodate the employee throughout the process of that injured worker's time off work. If you don't, you won't be subject to any penalties, but your exposure could go up the longer the person's off work. Next slide, please. Again, this is an area that we see a lot of litigation, bringing the employee back to work either at their same or similar job. The ADA requires an employer must bring the employee back to the prior position they held or a very similar in scope, certainly in pay, job duties type position. Again, unless you can establish it would be an undue hardship, primarily economically driven. The case of the EEOC versus Sears 2009 case talks about the wholly unreasonable type of approach employers might take according to the courts. In that case, Sears Roebuck, which to the degree it even still exists, they had a policy that it was essentially an up or out. And we've seen this with other types of ADA cases as well. There, the Sears said after a period of time, if you can't come back to work, we're terminating you, regardless of whether we might have work available for you. $6.2 million consent decree came down in that class action lawsuit. Similarly, in the case of EEOC versus SuperValue / Jewel, 2001 decision, $3.2 million equitable relief, where again, it was a restrictive policy without flexibility on accommodating employees after what was deemed to be an inflexible leave policy. FMLA similarly provides you got to bring the person back to work after those 12 weeks. If they're able to come back, or less than the 12 weeks, you got to put them back at the same position that they were prior to the leave of absence. In a recent case, a Seventh Circuit case, which generally we find to be a fairly conservative circuit, the case of Simon versus Co-op Education, in a case that came down this summer. In that instance, an employee suffered a head injury. That employee, when they were able to come back to work, she was not restored to her former position. She was paid the same salary, but her job duties were changed and reduced. In that instance, the court held that even though she still is making the same amount of money, this could impact her adversely when she would ever seek future employment. The job title switched, the job duties were changed. $60,000 in attorney's fees awarded in that case. Finally, under workers' comp, from a work comp perspective, and again, this might be different than looking at it from an ADA or an FMLA perspective, but not necessarily. From a work comp perspective, if I'm the defense attorney, I'm recommending to the client, if at all possible, bring the employee back to their pre-accident job functions, duties, salary. Because if you don't, if it's a serious enough underlying work injury, you're going to increase the exposure. You could be looking at worst case scenario at a perm total 6 to even 7-figure case, depending on the jurisdiction. Next slide, please. Well, we talked about a couple of the, oops, that might have jumped ahead there. Oh, no, one back, sorry. Spooky verdicts. Well, I've talked about a couple of spooky verdicts. There continue to be surprising cases with our courts, depending on the jurisdiction. And you just have to be aware of it, particularly if you're practicing Title VII cases. You really need to know the case law in all of the circuits, since it's federally controlled. In the case of Parker versus Brooks Life, it's a recent ADA case that came down this year. Now, in that instance, the 7th Circuit affirmed an Indiana District Fed Court decision on an ADA claim. The employee claimed that that she was terminated because of her MS condition, or multiple sclerosis, when only 2 days after she requested an accommodation to alter her work schedule. The employer turned that down. The employer's position was, this is an unsafe position for her. She could hurt herself or someone else. Now, interestingly, the court, despite that, despite the timing of it, the court said, we find that there was not an ADA violation here. The plaintiff failed to go through a PTO written policy process. She had been advised, you need to fill out the necessary paperwork for that. And she had been coached on that in advance, that if you have a health condition that arises like this, I would say if that were held in a decision was in a different circuit, different district, it might have been a different decision. So in that case, good spooky verdict in our favor from an employer's perspective. Another 7th Circuit case. Now, this case involved pregnancy discrimination, EEOC versus Walmart. 7th Circuit case rising from Wisconsin Federal District Court case. Now, while it was a pregnancy discrimination and sex discrimination case, again, it's relevant to the issue of job placement, job leave, and the like. So it's still helpful to look at. In that instance, the employer had a policy where they treated pregnant employees different than they did employees with workers' comp injuries. They had a policy where they would and could and did place injured workers on light duty work that they didn't provide to pregnant employees. Again, I would say if this was in a different circuit, it might have been a different decision. Next slide, please. Most states are at will, Michigan being one of the few exceptions from recent review, where you get a work injury as part of the settlement, it's an automatic up and out. Otherwise, Illinois, Indiana, many other states, you can't terminate someone because they had a work injury. There are valid bases, certainly, to still terminate someone. Extended absenteeism, violating company policies, no work available within that person's restrictions, no definite return to work date. We had a case we defended, went all the way up to the Illinois Appellate Court, Equity versus Eastern Illinois Food Bank this recently, in which the plaintiff had a work injury, albeit a disputed work injury. Ultimately, the employee was terminated. The employer terminated the employee because he could not provide a definitive return to work date. As doctor said, I can't tell you how long it will be. The employer had already accommodated a leave absence of about 5 months. Court rightfully determined if you, as an employee, can't provide a final time frame, we're going to err on the side of the finding that there was no retaliation, there was no ill will, ill motive there. Next slide, please. Another case in which the court was favorable to the employer, a Seventh Circuit case, Lutz versus United Trailers. This arose out of Indiana, Northern District of Illinois. There, the employee was injured outside of the workforce, failed to follow the company's call-in policy. Both an FMLA and ADA claim was asserted. There, the court said the employee did not follow the proper absentee and call-in policies. As a result, the court said that was a valid basis for termination. It was not a violation of ADA or violation rules. Next slide. On the other hand, a court decision example of a non-pretextual reason for termination was Casanova versus American Airlines, 7th Circuit, 2010. In that case, the employer had a zero tolerance policy for an employee who would lie. Most employers have that. The employee was fired for lying. And in that instance, the employee said, even though I didn't file a comp claim, you believed that I would file a comp claim. The court determined, the Seventh Circuit determined, there was not sufficient evidence of a pretextual basis for the termination. This was clearly an instance of the employee not providing sufficient information to the employer for them to believe there was any work injury to start with. Last slide, please. As with all areas of employment law, absolutely critical that unlike our fact scenario where we would have had serious problems, documentation, written documentation is absolutely critical along the entire path from discipline to potentially ultimate termination, layoff, job discharge, change in job status. All of those steps need to be followed. There needs to be adequate training of HR, of risk management, all the way down to the supervisor level. And two of our excellent corporate counsel today are going to talk about exactly that, how their workforces, how they train and make sure that their workforces at the supervisor and management level are well attuned to the need to fully document their actions. Procuring statements from witnesses, particularly co-employees, someone outside the management or the supervisor group. Again, absolutely critical. Someone who isn't necessarily part of the management group. Juries, courts, EEOC, many times they're more likely going to believe a fellow laborer, an hourly worker, than they are the supervisors, than they are HR or management. And an area where we see, continue to see employers trip up is where they don't apply their policies consistently. The exception being the case I referenced a few moments ago, where you said you can treat a work comp injury employee differently perhaps than you can someone that didn't have a work injury. But generally, consistent application of your leave policies, of your termination policies, of your discipline policies. That's certainly something that when you have a case at the EEOC, if it's not provided, the EEOC is going to ask for that. Comparators. How does this employee who's brought a claim fit in with others that aren't in the protected class. So that equal application is absolutely key to these types of cases. As Sean said, please feel free, not only during the question session, the questions you submit, but feel free to reach out to any of us with questions that you might have. Well, I'm going to turn this over now to the scary area of attorney's fees that you can encounter.
Thank you very much, Storrs. Great presentation. Hello, everybody. My name is Bob Sallander, and I'm happy to be with you today. I thought that talking about defending against attorney's fees would be an appropriate Halloween time discussion, because most of the time the statutes that provide for fee shifting do so to create fear. And so we're going to get into that a little bit today and talk about how we can ameliorate some of that fear. So what I would like to do at the outset, before I get into the body of my presentation, is give you a fact scenario. And at the end of it, I'm going to ask you to make a ruling. I'm going to ask you to put your ruling in the chat section. And it will be P for plaintiff or F for firm. And I'll give that code to you again, but so get ready for this. So this is a horror story for one of the two litigants in the case. It was an attorney malpractice case. The former client was seeking $94 million in damages. The law firm and its insurer hired a well-regarded national expert on attorney professional responsibility and ethics to defend the law firm in this case. Now, here's an important fact. That same lawyer had reviewed and approved the law firm's retainer agreement with the client. And that retainer agreement contained a prevailing party attorney's fees clause. The defense lawyer was successful at the outset in forcing the matter into binding arbitration, and the parties selected the expedited arbitration program at JAMS. Well, 2 years into the expedited arbitration, the JAMS arbitrator issued a partial final award in which he voided the fee agreement between the firm and the client because it did not comply with the rules of professional conduct. So that meant that what the firm was facing in this arbitration was a claim for $94 million in damages. It also had to prove under a quantum merit theory that it was entitled to any fees at all. And on top of that, there were insurance coverage problems. So the firm decided to change lawyers at that point in the case. And ultimately, the way the arbitrator ruled was that there was no legal malpractice. So there was a defense award on malpractice, and the firm proved by quantum merit an entitlement to $8.5 million in fees. So there we have a resolution of the key main issues in the arbitration. One issue remained, and that was the issue of prevailing party attorney's fees. There were cross motions. And so now I'm going to ask you, the plaintiff claimed to incur $12.5 million in prosecution fees, costs, and expenses. The defense claimed $4.5 million in fees, costs, and expenses. I would like you to vote in the chat now whether you would rule for the firm or for the plaintiff. So put F for the firm or P for the plaintiff in the chat, and I'll give you a minute to do that. I see that chat is disabled, so people are putting it into the Q&A. And so far, we are 100% in favor of the firm. So you can keep voting. I will tell you at the end of the presentation what the arbitrator decided in that case. I think we all know that the American rule for attorney's fees is that each litigant in a matter, they bear their own attorney's fees and costs. The exceptions to that are if that rule has been altered by statute or by contract. So we could spend a ton of time talking about these issues, but let me just give you a summary that under all federal anti-discrimination, anti-harassment, and anti-retaliation laws and many of the state employment statutes, prevailing employees are entitled to their attorney's fees. The fees are shifted to the losing employer. That's a one-way shifting. Provision for shifting fees incurred by the employer to the losing employee may be available under the Civil Rights Act of 1964 and the Americans with Disabilities Act that Storrs just talked about. But courts looking under those statutes have generally restricted recovery by the employer of its fees to cases where that were shown to be frivolous, that were shown to be unreasonable or groundless. So those are very high standards. Shifting attorney's fees to the employer raises the stakes tremendously, since it is not unusual in a single plaintiff litigation for attorney's fees and costs to be substantially more than any potential damages. So the first thing that has to happen in a fee shifting situation is determination of the prevailing party. It would really be easy to occupy the time available in this webinar to a discussion of who is the prevailing party. In fact, we could probably go on for days. It is an easy question where a plaintiff has won a net monetary recovery or where a defendant has received a defense verdict. But there are more complex circumstances, such as the fact scenario that I gave you at the beginning, where the outcome of the case is a mixture of favorable and unfavorable rulings. Plaintiff wins some and loses some. Defendant wins some and loses some. So in those situations, tribunals have considerable discretion to determine who is the prevailing party. So for purposes of our discussion today, let's just assume that the prevailing party is not you. And then we don't have to worry about the rest of it. So the question that we'll be addressing is, how will you defend against the other side's fee request? Let's go to the next slide, Aaron, please. So the ABA model rules establish that attorneys may charge only reasonable fees. And this fundamental rule is echoed in state rules of ethics and professional conduct. One of the things that you will then do to defend against the other side's fee request, other than establishing they're not the prevailing party, is to demonstrate how their fees are not reasonable. And I choose the word demonstrate carefully, because there are too many times where the opposition is merely a screed of this is unfair, this is too much, this is unreasonable, without demonstrating why. And in my experience, if you do that, the court is not going to listen to your opposition. In a recent example is an arbitration where the arbitrator awarded fees to the defendant because it was a defense award, And the fees were fairly substantial. And the plaintiff's attorney in that case didn't analyze the bills, didn't look at the time entries on the invoices that were submitted to support the fees, and just made an argument about how he could have handled the case for less. And in that case, the arbitration is requested by the defense, and that was upheld by the court. And not only did the court uphold that, it added to the fees for subsequent motions and efforts of the plaintiff. So you want to be able to demonstrate unreasonableness. Let's go to the next slide. There are 8 factors that the ABA says courts should look at in determining reasonableness of fees. Now, it's important to understand that courts are not limited to these 8 factors. They can consider additional factors, especially where the case is complex. And this ability to consider additional factors is really the key in complex cases. We'll get to that in a minute. But think about a case in which an employee alleges both wrongful termination and breach of an alleged partnership agreement. In other words, the employee was claiming that it was part owner of the employer, but also an employee. And the alleged partnership agreement contained a prevailing party attorney's fees clause. After trial, a jury trial, the jury determined that there was no partnership agreement, that had not been established, and awarded a minimal sum for unpaid vacation, unpaid and unused vacation. Then there were cross motions for prevailing party attorney's fees. The court in that case denied attorney's fees to the employee for obtaining the recovery for unpaid vacation, and awarded fees to the employer under the alleged partnership agreement, which shifted fees to the former alleged partner. I think that well, the award to the employer was ultimately in fees, was ultimately more than the award of damages that the jury had determined based on unused vacation. So the employer was received the net monetary benefit. Now, there's something that I want to point out in that case, and let's look at the next slide. Because the weightiest factors that courts consider are comparison of the fee charged to the value received, the experience, reputation, and ability of the attorney, and the informed consent of the client to the fee. In my experience, the experience, reputation, and ability of the attorney weighs quite heavily. And it's not the marketplace reputation of the attorney that matters, but it is the particular judge's or arbitrator's experience with the attorney in that matter that is usually considered. So in the example that I just gave you, where the judge wiped out the jury verdict and gave a net monetary recovery to the employer, I happen to believe, although I don't think the court would admit this, that it was the court's experience with the plaintiff's attorney that was a huge factor. And the example of that is that in the middle of the litigation, when the judge had made a evidentiary ruling that the plaintiff's attorney didn't like, he asked the judge whether she had had any experience handling these kinds of cases. So I think she let him know that by her ultimate award in the case. Let's go to the next slide. Now, as mentioned, one of the things that you need to do is determine who is the prevailing party. And courts do have discretion to determine that there is no prevailing party. This isn't going to be a good ground for appeal when the standard of review is abuse of discretion. If the trial court, who's listened to however many days of evidence, have determined that there is no prevailing party or that fees are unreasonable, it's highly unlikely that a court is going to overturn that. So let's go to the next slide, please. One way to demonstrate that your opponent's fees are unreasonable is to find inefficiencies in the billing. Inefficiencies often exist just because there are multiple attorneys working the case, and where there are multiple attorneys, there's just a presumption that they overlap in some circumstances. So there is in our jurisprudence a so-called 10% rule, where a court, without explanation and without any need to review the bills, can just do a 10% haircut. And so that happens, but you can't just ask for a 10% haircut. Again, you need to demonstrate why the court should invoke that rule. So let's go to the next slide, please. When you're defending against these things, you want to do some discovery. If you haven't done it pre-trial, you should ask for it at the time of the motions for attorney's fees. And sometimes courts will not allow the discovery, but other times they will. And what you want to do is get the fee agreement, because remember, one of the factors is what the client and the attorney agreed to pre-litigation. Courts are not likely to give litigants a bonus, if you will, for winning. If there was a 1/3 contingency and there's fee shifting, it'll be 1/3. This has to be assessed, though, against a lodestar, and we'll talk about the lodestar in a minute. Next slide, please. You're also going to want to look if there's no fee agreement, as in our initial example. It's got to be quantum merit, or what is a fair amount. And the agreement may be voidable at the option of the client, and then the agreement just doesn't matter at all. Next slide, please. You're also going to want to look at the invoices. The key, in my experience, to addressing fee petitions is really to roll up your sleeves and understand the invoice, and whether it's consistent or inconsistent with the fee agreement. And really what you're looking for is whether the amount of time spent on a particular task was reasonable, whether the hourly rate was reasonable, and whether those together, which constitute a lodestar, are reasonable. And also whether they are related to the matter for which fees may be awarded. Let's go to the next slide, please. In looking at the lodestar, which is hours times rate, you need to establish what is a reasonable hourly rate. What insurers pay their defense counsel is not considered a reasonable hourly rate for what plaintiffs charge their clients. And so that's usually not a winner. However, there are some published rate sheets out there. Let's go to the next slide. And the main one that, let's jump past this one as well. The main one is called the Laffey Index, which is put out by the Department of Justice. And it does a frequent review of fees charged in the Washington, D.C. area, and then it has upward and downward changes for particular metropolitan areas. So, for example, in the San Francisco area where I practice, there's the Laffey Index has a surcharge. In other places, there's a reduction. But the Laffey Index is generally considered the gold standard when you're arguing about hourly rate. So my time is up here, and I'd like to just tell you, thank you for your attention, but also tell you that the arbitrator in that first example did not find for the firm, as all of you voted for, but found in favor of the plaintiff because the plaintiff had voided the fee agreement and the fee shifting clause was in the agreement. Therefore, the law firm, which had won an $8.5 million fee as part of the arbitration, ended up being a $4 million judgment debtor because of the fee shifting in the voided agreement. Thank you for your attention. And at this point, I'd like to turn the time over to Tina Maio for her presentation.
Thank you, Bob. That was very interesting, very, very informative. I appreciate it very much. And I also appreciate everyone being here today. And I'm going to get to talk to everybody about the Dobbs case. As we all know, back in June of this year, the Supreme Court issued over a 200-page opinion in the case of Dobbs versus Jackson Women's Health Organization that ruled upon whether an abortion was a federally protected right. And we're all in this theme of Halloween and scariness. Well, this case and this situation is scary because there's so much unknown. So we'll go through the ruling, generally speaking, and how it affects employers and what we can do moving forward. But keep in mind throughout, this is going to be a changing area. The law is going to continue to develop. I'm sure there are going to be challenges in various jurisdictions based on what we discussed today. So the best advice I can give is just to stay apprised of the law and its changes throughout. If we can go to the next slide, Aaron, please. So what does Dobbs do? Yes, it does, in its 200-page opinion, overturn Roe v. Wade. It held that there is no constitutionally protected right to abortion, but it did not rule that abortion is illegal throughout this country. I know there was a lot of protest at the start. A lot of people believing that was what the ruling did, but it did not. What it did was put it back on the states, and it put it on the states to determine whether abortion should be legal, illegal, or whether there should be some limitations on the ability to obtain an abortion in that state. We can move to the next slide, please. So what is the current state of affairs at this time? According to the New York Times, about half of the states in our nation are expected to enact bans on abortion, either entirely or after a certain period of time into the gestational period or pregnancy. In some of these states, abortions are currently legal, and they're waiting to see how the courts handle bans and gestational limits to determine whether they can put the bans in place and to what extent. In the rest of the states, abortion is legal, but may be restricted or maybe legal outright. I know here in the District of Columbia, abortions are legal. There are no restrictions at this point. Next slide. Here's a couple charts, or three charts, I guess, not a couple, to show you where things stand in various states throughout our nation, from what states in the top left photo, what states have full bans, bans after 6 weeks, or bans after 15, 18, or 20 weeks, what states have it legal for now, with bans either blocked or bans maybe coming, remains to be seen, or in areas where abortions are legal, but possibly legal but limited. Next slide, thank you. So what does it mean for employers? There are various implications under laws federal laws. And I want to start off with that bottom arrow that I can't stress enough. You cannot forget your state and local laws. Today, we're going to focus on the federal laws because it applies to everyone. But so many states out there have laws that are broader than the federal law, and even local laws in counties that are broader. So you cannot, for example, look at Title VII and forget about your local anti-discrimination and harassment laws. Make sure you check at all levels to make sure what you're doing is in compliance. But the main laws that we'll be focusing on today, National Labor Relations Act, Title VII and Pregnancy Discrimination Act, which generally work hand in hand in this regard, FMLA and ADA. And you're going to hear a lot of things that I say are going to reinforce or repeat what Storrs said earlier, but that just tells you how important they really are. So let's move on to the next slide, please, Aaron, and talk about the NLRA, the National Labor Relations Act. A lot of employers get into trouble because they hear the NLRA and think union or unionized employees. That is a misconception. So please keep in mind that the National Labor Relations Act does apply to private employers as well. And what does it say? It protects employees' rights to engage in protected concerted activity. What is a concerted activity? Employees can complain, they can opine, they can express frustrations about terms and conditions of employment. And the NLRA says that employers cannot discourage or discipline employees for doing so. Now, I could give a whole webinar on when that act would apply, when it wouldn't apply, especially with social media being in place, but just generally speaking, employees have a right to express their opinions about workplace policies or conditions. So being mindful of that, how does that apply in this situation post Dobbs? And the best way to put it would be with an example. If you have employees that are saying, well, you know, our company, they don't do enough for employees who want to get safe and legal abortions, for example, providing travel time or finances for travel. Their comments in that regard are protected. On the flip side, if you have employees saying our company does too much, they should not be paying for travel or giving time off for people to travel and get abortions, that is also protected activity. So it doesn't have to be one way or another. And one thing you'll hear me say quite a bit today is it's not the employer's job to get into how we get to where we are. If we're talking about an employee getting an abortion or post-abortion medical conditions, it's not the employer's job to get into the morals of it, the religion of it, the politics of it. For our purposes, what you want to focus on are the health conditions, the disability status, the serious health condition status, and treat individuals equally. And we'll get into all that detail in this presentation today. But that's the safest way to deal with the post-Dobbs decision. Aaron, if we can move on to the next slide. So looking at a report from Bloomberg Law, and it's absolutely correct. It says, as it stands, employers can generally still expect to be held liable under the Pregnancy Discrimination Act and Title VII of the 1964 Civil Rights Act if they treat employees differently for having had an abortion, seeking one, or choosing not to have one. Some states, typically those where abortion will remain legal post-Dobbs, have heightened pregnancy discrimination protections or explicit abortion non-discrimination statutes. The bottom line here is that regardless of whether an employee had an abortion, is seeking one, or choosing not to have one, you're dealing with pregnancy. You have an individual that is or was pregnant. So discrimination against that person based on those status is going to fall square within the four walls of the Pregnancy Discrimination Act, and you're going to expose the company to liability. Along those same lines, under Title VII, an individual, and not always, but 90% of the time, I would say, if not higher, the individual who is pregnant is going to be a female or identify as female, and they're going to fall into a protected status. And if you treat them differently for getting pregnant, having an abortion, not having an abortion, seeking one, you're going to fall into discrimination based upon gender identity, possibly gender or /sex, and other disabilities. And we'll get into that more with the ADA. But if you treat individuals who are having an abortion in one way, or seek to have an abortion, or are not having an abortion in one way, and you treat them more favorably than other disabilities, for example, then you are going to expose yourself in the company. And I say yourself because in some jurisdictions, like here in DC, under the Human Rights Act, there's individual liability. So you have to be careful of that as well. But you're going to expose yourself potentially, but definitely the company, to claims of discrimination based upon various protected statuses and or disability. Erin, next slide, please. Now, under Title VII, what if an employer offers health insurance? Well, the health insurance, at least at the way things stand right now, health insurance is not required to pay for coverage of the abortion process itself, except where the life of the mother would be endangered if the fetus were carried to term, or if there are medical complications that have arisen from an abortion. So again, we're talking about the medical condition of the individual carrying the baby, right? So if that individual is facing life-threatening conditions, if that baby's carried to term, or if there has been medical complications after a procedure that happens to be an abortion, then the health insurance will have to kick in and provide coverage. Now, employers can choose to provide more coverage. They can provide health insurance coverage for abortion-related services if they want. But in doing so, keep in mind that you need to treat disabilities in the same manner. So if you're, for example, going to provide paid leave for someone to travel, or financial benefits for someone to travel to obtain an abortion, what are you going to do when someone needs to travel to get the best care for cancer? Are you going to provide those same benefits? And I would recommend that consistency be the key, and that, yes, if you are providing those benefits for one service or one health condition, then you should do so as well for other health conditions or disabilities. Following the Dobbs decision and the enactment of several state laws banning abortion, a lot of companies have announced that they're going to do just that. They're going to provide health insurance benefits to cover travel costs for employees who have to travel to another state to receive an abortion. And I'm sure most, if not everybody, has heard about this in Texas, because Texas has a ban on abortion. But there are groups out there, in this case in Texas, it was a legislative group, and pro-life groups that are threatening lawsuits or legislative action to ban such provisions. And what they're doing in Texas, they even went after the attorneys who were advising the companies, saying that they would litigate or prosecute against them and also pull their licenses to practice law. And what they're basing that on are aiding and abetting statutes. So if the state has a law that makes it felony to have an abortion, then anybody who aids and abets, in the way of doing that is allowing someone to have money to travel to another state, even though it might be illegal in that other state, they're threatening to bring lawsuits or legislative action to hold those individuals who have assisted criminally liable under aiding and abetting statutes. Erin, next slide. So what about the FMLA leave? Well, FMLA has already been established for some time now, that where an expected mother has an incapacity due to pregnancy, that's covered. It's also said that miscarriage is considered a serious health condition. And I don't know how many of you out there have known someone who's had a miscarriage or may have suffered one, but in the medical terms, a miscarriage is a spontaneous abortion. That's how it's classified in medical terms. So I think it would be a safe assumption, and this is one of those areas that I'm going to say, we're waiting for more law to develop, and a lot remains to be seen. But I would highly suspect that if the Family Medical Leave Act is covering a spontaneous abortion, because again, we're focused on the medical condition of the individual post-pregnancy, I think it's probably going to be a safe assumption that even if an abortion is elective, that it's still going to be considered a serious health condition, because the body is going to be in the same condition post miscarriage as it would be post elective abortion. So under either situation, I think we're going to find that the FMLA will be covered, will cover the situation. So an absence from work to obtain and recover from an abortion, whether spontaneous or elective, it's likely to be covered. And state and local laws may also provide for this as well. And what I've found is the states and local areas that actually don't ban the abortion are going to be the states with the more liberal Family Medical Leave Acts. So you have to really be conscientious of your local FMLA laws. Some states just follow the federal, and that's great, but many other states have their own and they're more expansive. So make sure you comply with the state and local laws as well as the federal law. And keep in mind that the leave under FMLA, it might include time off for related or necessary travel. For example, if you have an individual who's pregnant and they're having complications in that pregnancy and need to travel to get the abortion to deal with the medical complications, the time off for that travel could be considered part of the FMLA. So the safest course is to follow FMLA provisions, allow the FMLA leave, and just keeping the mental focus as the employer. What is the medical condition we're dealing with? Doesn't meet the definition of serious health condition, regardless of how we got there. And if so, FMLA, assuming they meet the minimum hours and length of employment time, it applies, and we should allow for the FMLA leave. Aaron, next slide. That dovetails us into the ADA, or the Americans with Disabilities Act. While pregnancy itself is not a disability under the ADA, pregnancy-related impairments have been, in various situations, considered to be a disability. So common disabilities or pregnancy-related disabilities that have been identified: high blood pressure, severe morning sickness, limited mobility. But as you might imagine, the statutes and regulations don't provide an exhaustive list. So covered employers are required to offer employees reasonable accommodation unless such doing so would pose an undue burden on the employer. And what's an undue burden? Significant difficulty or expense. And if you have an individual that has pregnancy-related complications, or their life is threatened if they carry a baby to term, and have to take time off, travel to obtain an abortive procedure, they're likely going to fall, pretty likely to fall under the ADA. Because let's think about this. Someone has a condition that is threatening their well-being with the pregnancy, and they're electing to terminate the pregnancy to deal with their disability. That is going to be an issue that's covered, a disability that's covered under the ADA. And what does the employer do with it? Well, the employer should sit down, go through the interactive process with the employee, find out what the employee needs, what would be a reasonable accommodation, keeping in mind that just because an employee demands a certain reasonable accommodation doesn't mean that that is what is ultimately going to be provided. And on the flip side, keeping in mind that just because a reasonable accommodation requested by an employee might not be reasonable, it might be unreasonable, that doesn't end the discussion. The discussion, it needs to be interactive, in which you sit the individual down saying, okay, what do you need? How can we work together to provide you an accommodation, if possible, to allow you to be able to perform the essential functions of your job? And that's ultimately what the employer's obligation is. Work with that employee. Again, keep in mind that the disability is what we're concerned with, not how we got there or any personal views leading up to that. So if we can move on to the next slide, please. So if an employee seeks time off for reasons related to an abortion, such as travel out of state to receive abortion care, your obligations in the ADA will be triggered if they have a pregnancy-related disability. And I want to point out here, because I know the question is going to come up, what if someone has a completely healthy pregnancy and they still want to receive an abortion? Well, that, and again, we're waiting for case law. We have to wait for this to develop more to see where this goes. I would imagine that if it's a healthy pregnancy and there's no pregnancy-related disability whatsoever, up to that point, there's no ADA coverage. However, if that individual does obtain an abortion, that individual's body condition, medical condition following the abortion is likely going to be a temporary disability and will be subject to the ADA. So again, we don't worry about anything but where's the disability kicking in? When does it kick in? When do we have our obligations under the ADA to reasonably accommodate? So once there is that disability that falls under the ADA, you want to meet with the individual and go through the interactive process, find out what needs to be done to help them do their job. Is it time off from work? Is it working from home? Post-COVID, that is a very available accommodation. People are asking for it quite a bit, and COVID proved that it's not normally an undue hardship. There are cases where it is, but the courts are more willing to look at it as a reasonable accommodation. And as long as the employer would not be unduly burdened by offering this accommodation, then it's going to be expected to be provided. In the case law, I mean, the courts, if this were to go to litigation, would say, where did you go with your discussions as far as the interactive process? Why was a certain accommodation not awarded if it was denied? And tell me where you were unduly burdened. So as long as you check off their boxes, and we can go to the next slide. And the most important thing is engage in that interactive process. And you'll see when we get to our takeaways, document everything. Then that'll be the best way to defend your company against any claims based on the ADA when it comes to abortive procedures. Next slide. Now, we discussed at the very beginning that how an employer deals with abortive procedures post-Dobbs, how it can also impact other health concerns, disabilities, serious health conditions that are unrelated to abortion. You need to be very careful that everything is applied equally. You want to follow your policies. You want to have consistency. So again, if you're affording employees paid travel to get abortive care, keep in mind when someone asks you for travel time for care for another serious health condition, that you've set precedent, and you want to be very cautious of not committing disparate treatment based upon protected status, based upon disability. And one area that this is going to dovetail into, based upon another recent ruling, is medical treatment for gender or transgender issues. Next slide. In a split Fourth Circuit panel decision, the court in the Williams versus Kincaid case has held that gender dysphoria is a disability. Next slide. So if gender dysphoria is a disability, and this decision goes unchallenged or is upheld, then we need to, as employers, we're going to need to make reasonable accommodations for medical treatment in this regard as well. So if you have an employee that has gender dysphoria and wants to travel to get medical attention and or surgery to have gender alignment, then you're going to be looking at them in the same way you're looking at the abortive procedures. And if you provide paid travel time for the abortive procedures, you're going to have to do so the same way with gender dysphoria. These two areas are going to be very consistent. It's going to be very interesting to see how this law develops. And as we've seen in the bakery case in Hobby Lobby, there are going to be challenges to this, and we're going to have to sit back and watch and see how it all plays out. Next slide. So just to wrap things up a little bit, talking about our key takeaways. So you want to, and I know I've said it a million times, but hopefully it's stayed in your minds, apply all policies consistently and reinforce your current policies. Engage in the interactive process when you have any requests for reasonable accommodation. Document everything. Keep abreast of the law as it continues to evolve. And be mindful on how your decisions on abortion-related matters impact other areas. And be aware that decisions could potentially result in exposure to claims or liability under your state laws. Don't forget about those state and local laws when dealing with these issues. And that wraps it up for me. And I want to thank you for your time today. It's been my pleasure.
Tina, thank you so much for taking on a sensitive and complex subject and doing such a wonderful job. Thank you. Our last segment of the day is our roundtable. We have two of our fellow lawyers from the MPLA with us. Kyle Kunst is a prolific and successful litigator in the New York office of Gallet, Dreyer, and Berkey. His education spans UC Davis, as I recall, and New York Law School. So he literally strides the continent with his education and his practice. And then Brian Kluk is an attorney in the Minneapolis office of McCollum Law. He is an amazing writer and teacher of the law in Minnesota, and he's going to be speaking with us. But what I'm most excited about is to have Stacy Hinners with us. Stacy is the Labor, Employment, and Benefits Legal Counsel for OI Glass Incorporated. If you didn't know this, and I didn't until I got to know Stacy, OI Glass employs 24,000 employees and is one of the world's largest manufacturers of glass bottles and has been since 1903. Stacy has a fascinating history. Like myself, she's been practicing for 20 years, but she started her career as a plaintiff's lawyer. And then in 2013, moved from plaintiff's work to an in-house position with a Fortune 200 company. And last, but certainly not least, is Noah Frank. Noah is the Associate General Counsel for Enlivant, an assisted living facility located in 26 states. Noah is a graduate of the University of Illinois, both for his bachelor's, his master's in human resources on topical today's subjects, and his Juris Doctorate degrees. Welcome all of you, Noah, Stacy, Brian, and Kyle. Noah and Stacy, let's start with y'all. Is the Bermuda Triangle that Storrs talked about earlier, implicating corporate counsel like you, and in what ways?
Oh, well, thanks, Sean. In quite a few ways. I think it's, to some degrees, I think it's our day in and day out if we're not paying attention to it. With our company, one of the things I think that we have a lot of advantages of is that our HR and our risk management work really closely together, which is fortunate because we avoid some of those claims that Storrs talked about, the leave interference, discrimination, and workers' comp retaliation. So coordinating those together really, I think, is beneficial, ensuring that we're exhausting FMLA when an employee is out on workers' comp, and when their FMLA leaves, that we are appropriately accommodating them. Stacy what are you guys seeing?
Yeah, I think it's certainly, by the way, I apologize. My computer has a poltergeist, so it's in fitting with the theme for this. So no, I think it's a lot of the same. And I think that I think really kind of two things that we're careful about in training, aside from, right, everybody making sure that they're not working in silos, and that we are kind of thinking of, I like to break down these situations in 3 buckets. Help, so in terms of accommodation, like what can we do to help somebody work, time off, and pay. And really, when we go to train, think of those as 3 distinct buckets. And then I start to matrix out workers' comp, ADA, FMLA. If you're in a state where there's a paid sick leave or maybe some other benefit, or short-term disability benefit if you have it internally. I like to create that matrix because those really are like 3 separate kind of buckets that we need to consider. And then they come with their own kind of considerations and applications depending on the facts. So that's one. And then really the second thing too is being mindful of words we use. I think the word accommodation is conflated a lot of times with temporary light duty, and it causes confusion both to management and employees in terms of setting expectations and defining what the purpose of whatever you're doing is. So if you've got somebody with work restrictions that are, we talked about pregnancy related, work comp related, that's a different analysis than the ADA accommodation, right? Which is really, instead of removing a duty or giving you kind of
COVID cases falling under workers' comp, or?
Yeah, I haven't seen a lot of COVID cases fall under workers' comp, I think, because there were such robust, number one, the period of time for most cases was short, and there was such robust, I think, benefits related to that. So I haven't seen a ton of workers comp cases, although we are starting to now see a little discussion, although not a ton, of the long haul COVID or impacts of COVID on certain employees.
Got it. Are you guys, for FMLA purposes, are you guys requiring employees with COVID to go through the full paperwork? I know for us in particular, our employees couldn't get in to see doctors when the pandemic first broke out. I know we were making exceptions to the rule for those cases.
I think you had to, right? It was kind of this, if I never hear the word unprecedented again, that'll probably be fine, but it was an extraordinary time. I do think now the shift though is, how do we start to, where we can, and pretty much we can in most states, slide into managing COVID like we would any other type of virus or illness. And I think that's kind of been the direction we're trying to move in now, because continuing to manage COVID today, like we were in, May or June of 2020, is probably not really sustainable for us long-term anymore.
I agree with that.
Well said. How about triage instead of unprecedented?
Yeah.
Or maybe catastrophe, for that matter.
Every day it was wild times. I think it was wild for everybody, but particularly if you were responsible for, the rights and the safety and health of a workplace, particularly an essential. Noah, you guys were certainly essential. We were too, as supplier to the food and beverage industry. It's a lot to consider and balance. So, and then, obviously we want all of our employees, as many as we can, at the end of this. So we certainly don't want to be making hard and fast decisions that cost us good workers when we know those are in short supply.
We actually went the opposite. So my CIO and I still joke that we thought this whole thing was going to be 2 weeks long. And then we back to the office. When we went remote, I said, should I bring my base station home? I said, nah, we're back in the office 2 weeks. Okay. You know, didn't happen. We're senior assisted living, and so we're really dealing with the most vulnerable of populations, people who succumb to COVID-19 at a much greater rate. And in early 2001, we actually made the really hard decision that we were going to mandate vaccination. And in the summer of 2001, we actually terminated employees who refused to get vaccinated for personal reasons. And then we obviously had to go through the accommodations process for both religious and medical for those who were unable to do so due to religious objection or medical reasons. But that had a substantial impact on our workforce as well.
Yeah, and you guys are certainly in a tough spot, given your core business and the high stakes involved with the people you're serving. We weren't quite in that headwinds that you were, and we tried really hard to maintain as much, I guess, flexibility or autonomy for our employees as we could. OSHA made it interesting for a hot minute. And that was an exercise that I think anybody that was, whether you were a federal contractor or subject to OSHA or both, that was a really interesting exercise with them that ultimately was, at least on the OSHA side, paused,
Yeah.
right?
I might break from our industry on this one, but I was actually in favor of OSHA's vaccine mandate because number one is it met our company's mission, vision, and values and desire to keep our seniors safe. But I also really wanted one federal standard because, being in 26 states, we were dealing with a real patchwork of laws on these topics, and we still are.
Yep.
And things remain to be seen as to how they're going to shake out.
Plus, I would have leveled the playing field for you, right, in terms of vying for labor and things like that, because the rules,
100%.
everybody been playing by essentially the same rules. I am grateful that it didn't roll that way, but yes, I can empathize with your position.
Yeah.
Well, Noah and Stacy, shifting gears a little bit to Tina's topic, what are y'all seeing, if anything, on Dobbs related issues, and what strategies are you employing?
Yeah, it's interesting because it's interesting where the law is kind of a leading force for social change, and where the law is a lagging kind of indicator. And I think here, at least in like Fortune 500 America, it's a bit of this decision, Dobbs, is a bit of a lagging indicator, because from most big businesses, we have, as a condition to being able to do business, really have to put together these like robust ESG and corporate social responsibility strategies, and you're seeing movements into diversity, equity, and inclusion. And again, these aren't just like nice to have or kind of lip service sorts of things. These are, corporate strategic initiatives that are expected by your customers, not just in the US and globally. They're being watched by investors carefully, and at times influenced by investors carefully. And now even being, I think, overseen by the SEC, that making sure that you say what you mean and mean what you say. So I say all that. I think the Dobbs issue, we're not seeing, in manufacturing, I've not seen a ton of impact to it, but I think, the two questions aren't just, legally, what do we have to do, but also more importantly, like from who we want to be as a company, a culture, an ESG, a diversity, equity, inclusion standard, like what are we going to do? What should we do? And so I have a feeling, I guess it's nice to have the Supreme Court, I'm sorry, on the Dobbs issue, it's interesting what the Supreme Court does. I don't know that it necessarily is going to influence, the way our business would approach it, other than these technical issues. If you're dealing with ERISA, if somebody needed medical care a year ago, I don't know that we would handle it much different than we would today.
Ryan, you have some experience with post Dobbs. Can you share that with the audience?
Yes, absolutely. And I kind of just piggyback there. There has been kind of some significant shifts in corporate culture in the last few years that are potentially raised by Dobbs. It used to be that employers were kind of expected to keep out of these types of hot button political issues. But in the past few years, there's sometimes an expectation that an employer is supposed to take a stance or is supposed to jump into these issues and address them with their employees and possibly facilitate some of those kinds of discussions. As Tina mentioned, it's important for an employer to be neutral in these kind of situations. When you're dealing with these issues that implicate religious freedoms, and as Noah just mentioned, the experience with COVID in the past couple of years has brought forth issues like religious exemptions for things like vaccinations. Many people object to or could object to abortion on religious grounds. And it's important to understand that if an employer takes one particular stance, either pro-abortion or against, there are a lot of passionately held issues within a body of employees, and you could be potentially creating a hostile environment for some of your employees, depending on the stance you take. So, no, I was wondering, you've dealt with the potential religious objections to COVID. Have you experienced anything like that with in the wake of Dobbs with abortion?
So we haven't. The interesting thing is, we're senior assisted living, we're healthcare. If you were to take a dart and throw it into our population of employees, first of all, I'd be really mad because you're violating our workplace violence protocols.
Sure.
But you're probably going to hit somebody who's, aged 18 to 27 and female, and probably, majority lower income. So you're running into people who don't necessarily have the greatest access to healthcare, and we look at this as being a health and safety issue. One of the issues going back to Roe is that abortion has never been unavailable. Legal, safe abortion is what Roe really guaranteed. And so now we're looking at this as well, even in states where it's unlawful, there will still be abortion. It just won't be healthy and safe. And I think that what we're seeing in the news is, the direct fallout of that at the hospitals. They're seeing more women come in with, severe complications from unsafe procedures. So we have not seen religious objections to this. We're not providing medical benefits for this, but we are providing support in other ways to ensure that our people can get the healthy and safe procedures they need to, because we don't look at this as I had a fun time last weekend, now I'll just get an abortion. I mean, this is, substantial health issues, ectopic pregnancies or major complications. And some people are just unable to get those procedures because of the current state of law.
And no, I think that's a great point. That something that I can make kind of my final emphasizing point is that in the wake of Dobbs, how it's changed from being kind of a top-down federal issue for everybody to all of these potential state-by-state differences. And even just so far, we haven't even gotten to major legislative sessions in the wake of Dobbs, or, we've seen a couple things like state referendums and some trigger laws, but there's still a potential for a lot more coming, a lot of changes state to state. And you have to keep in mind now that even if a state decides one thing, now because there is no Roe anymore, a state could change its law the next year or in the next couple of years. So it creates the obligation in employers to be constantly vigilant with all of the changes that you could have jurisdiction by jurisdiction.
Yeah.
And,
wanna jump in.
I'll throw
Go
in,
ahead.
I was going to say on the, I think it's to Tina's point, I thought the point about being consistent with approaching abortion in the same way that you would approach other types of, I think that's an interesting point, although certainly like if I'm looking for cancer care, I may not have this legislative like kind of complexity to weave through, but get that. I don't think you're going to see a lot of corporations be neutral. I think you may see one of two things happening. And I'm not speaking specific for my company now, but just in general, you're already seeing it where, I mean, certain companies were, I mean, they were prepared within the hour after the Supreme Court issued its decision with their, you know, what they were going to do next in terms of benefits. They're going to follow what they think their customers want. They're going to follow where they think what their talent wants. Like if I'm fighting for employees and I really want to be an employer of choice for employees, like that's what they're going to push for to the extent they possibly can. And it's legal. I think the other bucket of people is they're just going to sit back and kind of wait and see because of the volatility and kind of things yet to shake out on this issue. But I will say maybe a slightly different view. I don't know if I had an employee who said, you know, well, I don't think I'm against abortion. I don't like that as a Fortune 500 company, you're providing benefits specific to abortion. And I think I have a claim for hostile work environment because of my religion. I don't know if I follow that too much, or I would worry about that as a huge risk. I mean, right now, most Fortune 500 companies, or quite a few of them, have certain benefits for, you know, gender and sexuality that may not align with everybody's religious views. And I'm not aware of any of those giving rise to individual claims for you know, a hostile work environment under religion. So I say all that. I mean, I do think you're going to see DE&I and ESG be the leading indicators and kind of the compass for what a lot of corporate America is choosing to do as opposed to a decision like Dobbs.
I'm going to jump in at this point to all of our attendees. We are almost done, but we have two more speakers, Kyle and Storrs, before we completely wrap up. And then, of course, if anybody has any questions, please stick around or put them in the Q&A box. But for anybody who needs to grab lunch or move on with their day, we won't be the least bit offended. But as you can see, with these interesting subjects and with these phenomenal speakers, we could talk for hours on end about this. So, Kyle, I'm going to turn to you. In our previous webinar, you had given us an update on the current state of mandatory binding arbitration, and in fact, it's people's obtaining relief from it in sexual harassment, sexual assault cases. Has anything changed on that front to update the folks about?
Yeah, I had previously reported on the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021. And that act is a federal statute which prevents enforcement of arbitration clauses where the underlying claims relate to, and that's in the statute, relate to sexual harassment or sexual assault. And that's true whether such claims are filed under federal, tribal, or state law. Now, that act is applied with respect to any dispute or claim that arises or accrues after the date of its enactment. And it was only enacted March 3rd, 2022. Very recently. And so courts to date have really solely grappled with the issue when this particular statute has come up as to whether or not the claims have arisen or accrued prior to the enactment. And in the vast majority of those cases, they have not. Typically, the plaintiff was terminated at some point or ended their employment at some point prior to March 3, 2022. And so the vast majority of courts have determined that the act simply does not apply and they're forced to go into arbitration. One thing I think that practitioners and really anybody who's on this webinar will be interested in is when you have a complaint that contains causes of action that relate to either sexual harassment or sexual assault, and when you have claims that don't relate to such claims. Now, the legislative history indicates that those unrelated claims are still supposed to go to arbitration while those related claims are supposed to go to court. I would be surprised if courts would permit that to happen and split those claims, but that's something to keep our eye out on. And then finally, I had also previously reported on the Forced Arbitration Injustice Repeal Act of 2022, the FAIR Act. That is a much, much broader proposed piece of legislation. It was passed by Congress and in mid-March of this year, and that would apply to prevent arbitration of employment disputes, consumer disputes, antitrust disputes, or civil rights disputes. So it's much, much broader. However, since passing in Congress in March of this year, it's gone on to the Senate Judiciary Committee and it hasn't moved since. It doesn't look like there's much interest in it. Thanks, Sean.
Certainly, Kyle. Thank you for the update. And for anybody who is in the financial services industry, you'll know that FINRA has recently also barred mandatory binding arbitration in sex harassment and assault cases within its arbitration scheme as well. And then lastly, because this is supposed to be spooky, we're going to bring Storrs back in to talk about the first verdict, and boy, was it a big one, under the Illinois Biometric Information Privacy Act.
Thanks, Sean. Yes, for those of you who aren't familiar with this act, it's been in place for some time in Illinois, the Illinois Biometric Privacy Act, which provides that you cannot, as an employer, require an employee to use their fingerprints, eye scans, or other type of genetic private body parts, essentially, as a means of tracking their arriving at, leaving from work, going to lunch, unless, and I underscore, unless you get their written permission to do that. And in this huge case, the jury came down with a multi-million-dollar verdict against, I believe it was 40,000 or so class members, in which they held that there was a violation of this policy, in which the employer did not secure their permission of the employees to be scanned or provide their fingerprints and the like. We have, since this policy came about, we have recommended to employers, and there's a pretty simple form you can use, submit this form to employees. It's optional whether they sign it or execute it or not. If they don't, they can't be punished or retaliated against. Then you have to come up with, again, some type of alternative method, such as for attendance, for example, such as if you're working remote, you enter in your computer when you're starting your day, when you go on breaks and the like. But it's coming. It's going to be something we're going to see throughout the country in the coming months and years. And it's just the start of what's going to be a very expensive proposition, particularly in class action matters.
Storrs, do you think if employees refuse to sign that form, that they can't be terminated?
I don't think they can be terminated. And we've been asked that by clients. And again, it's this statute, as we interpret it, as something that you have to give employees the option of either agreeing to go through this process or not be disciplined for not doing so. And again, having to use some other type of timekeeping method, such as calling in, or if you're going into the office, checking in at the beginning of the day, signing in a sheet, or again, entering it in your computer. But short of, if you make it mandatory, yeah, I think it's going to set you up for a lawsuit. And a similarly interesting question is, what about someone you're thinking of hiring who declines? Same thing. I think you're going to run into adverse litigation if you don't hire someone because they would decline to sign or agree to this policy.
Do you think employees have the right to rescind their their acceptance?
Probably so.
Sorry, I'm putting you on the spot.
Yeah, probably so, because again, it's a conditional situation. So if someone no longer feels comfortable with their genetic DNA being used or shared, and the whole point of it is employers are not supposed to share it, and even if they don't share it, it doesn't matter per the policy. So yes, I think in fact our policy, our company policy is it can be revoked. Others may disagree with that, but I think it's I think it's going to be very flexible for employees.
Surely it's in the employer's best interest to not only revoke it, but purge it from their system once they're gone. At least then they're not going to be the responsible party for a hack that gets their thumbprint.
Absolutely. Yeah. No, that's an excellent point, Sean. There's as much cyber litigation as there is privacy violation litigation these days.
Well, maybe this will be a main topic in our next event yet to be scheduled. But for everybody who is still with us, thank you very much for attending. Both this webinar and the one we did earlier this year are available on Perrin's website. You can go back and watch the recording. You can obtain a copy of the slides, which will also be sent out by Perrin when this is all done. And there's hope. As much as and as comfortable as the Zoom presentation is for each of us in our respective towns, it is our goal, and certainly Perrin's goal in partnership with them, to put on a live employment and management seminar sometime in the next year. So look for that to be rolled out, look for dates, and hopefully we will all meet again in a lovely tropical location that hasn't been ravaged by hurricane. So keep Florida and the other victims of Hurricane Ian in your prayers, and thank you for your time today. And we look forward to your feedback as part of the CLE and CE process. Amy, anything else we need to say here at the end?
No, I think that's it. I'll send out all the information after the webinar, and we'll get your CLE processed.
All right. Thank you to our speakers, and thank you again to our attendees for joining us. I think we're going to call it a day at this point.
Thanks, everyone.
Thank you for having us.